Hello, everyone. This is week 3 and a quick introduction. What I wanted to do was cover the item that we dealt with last week, which was, are you kidding, or something clever like that, about what was missing in the Butler versus McCoy complaint. A few of you got it. Some of you did find some other more technical issues, and I thought that the jury demand was more important, and I'll explain that. Everybody that fears litigation usually fears the jury. The jury is going to be individuals who can be swayed by emotion and who necessarily are not nearly as legally trained as perhaps a judge, certainly, so that their decision can sometimes lead to verdicts that are perhaps a little bit excessive, and all companies fear that, the idea of what will happen when that jury goes back in the room. So not having a jury demand, particularly for a case like this, where you have pain and suffering, is quite an oversight. So within a day or so, they go in and they file the proper document. A jury demand is so easy. Let me show you. I'll link to the court rule, which is 1007. And if you look at 1007, let's see if I can get that. Well, if you look at 1007 yourself, my picture is slightly in the way. But it says at the end of 1007.1 jury demand waiver, in any action where right to jury trial exists, the right is waived unless you file and serve a written demand for a jury trial not later than 20 days after the last permissible pleading. So the last permissible pleading could be quite a ways. And the demand can be made either by an endorsement on a pleading or by a separate writing. So what that means, and I hope I can demonstrate it to you, is that you can either simply write on your complaint, as I did, call it complaint and demand for jury trial, and then at the end, after the signature by the attorney, you put another little demand for jury trial right here. Plaintiff hereby demands a trial by jury for all issues, and signs it. That would be the endorsement. A separate paper would be simply the caption of the case, and where you give the title of what the document is, you'd call it demand for jury trial. You'd say exactly that same language, have the attorney sign it, and you've what we call perfected, that is, saved your claim for a jury trial. The language of the rule tells you that if you haven't gotten it in by the end of the last permissible pleading with a time limit there, you're going to waive that right, and that's a serious loss. Think about this case, for instance. The hope that Mr. Butler and his friend have is that this case will go before a jury and they'll get a very large award. If it doesn't have a jury and it goes before a judge, judges are going to be much more skeptical, I think, and probably less generous. I think most everybody that has ever dealt with the court system would agree with that. So that's what I wanted to let you know, and that's all that simply needs to be put in. A couple of you made some interesting points about minor issues that were missing, and we'll talk about those a little bit later. The reason that this was more significant was this would seriously prejudice the value of their claim. The other instances where there wasn't an address in the caption for the first pleading, and a couple other minor things, as I recall, aren't going to affect the value of your claim. So maybe this will put everybody at ease. When you send something in to the clerk of the court, they do not have the right to reject it as long as you meet the certain limited duties that we've discussed already. That is, it has to be on certain paper, it has to be in black and white, it has certain other limits. But they can't, the clerk's office or the prothonotary or whoever it is, can't look at things and decide, you don't have a jury demand here, you have this there. They do not have the right to do that. They have to file a document if you pay the filing fee and it's colorably a complaint. That has to get filed. So that may put you at ease, everybody. This week we'll deal a little bit with a preliminary objection use, and it is an interesting feature of Pennsylvania law that I think you'll find is extraordinary. Federal courts do not have preliminary objections. They actually use motions. And while we haven't covered motions yet, motions are a request to a court to intervene in a case and give you some help. For instance, these sorts of things come up all the time. You request a document from your adversary, or you want to schedule a deposition and you can't get cooperation and they will not cooperate. Sometimes you have to bring it to the court's attention by a motion, and you move before the court and you ask for help, and you tell the court what's going on and you spell out exactly what you want. The other side gets a chance to reply, and at the end of the day, the court will give you a ruling, and that's what a motion is. Preliminary objections, which again only exist in Pennsylvania's courts, are a little bit like motions and are particularly valuable and heavily used in Pennsylvania's practice. Further, we'll deal with answers, we'll deal with new matter, we'll deal with affirmative defenses, which is the same as new matter, we'll deal with counterclaims, and we'll deal with cross claims. And there are sections further down that will deal with that. All right, I hope you have a good week, everyone, and I appreciate all your hard work. Thanks again.